Philip talks taxes. He has been for over 45 years, and there isn't a human on the planet with more experience solving problems on behalf of taxpayers. He wants to solve your problem whether you know you have one or not. So if you do have a tax problem, get a hold of him at his office or his website. If you don't have a tax problem, your current taxes is our tax system itself. So let's get into the policy issues of today. The main one being an actual win for taxpayers with the Taxpayer Assistance and Service Act, which is, to my understanding, a combination of a bunch of different taxpayers' rights issues, bills that were put together and kind of coalesced into one separate issue. So what are the things that make up this bill, and what is the biggest issue that we should be focused on here?
Well, first of all, let's not pop any corks yet, because the Taxpayer Assistance and Service Act has not been signed into law by the president. It is working its way through Congress in a couple of different pieces. Earlier this year, there were a number of different factors presented to the Senate Finance Committee as changes that need to be made to the Internal Revenue Code to help people better deal with the Internal Revenue Service. This is not a dollars and cents tax law, right? So this doesn't create more deductions or reduce tax rates. This is the procedural and administrative stuff that will help people better protect themselves from the IRS. So there was a lot of different components to the Taxpayer Advocate, to the Taxpayer Assistance and Service Act. Some of those things have been broken down into separate bills. There was a disaster relief bill, there was an electronic filing bill, there was a National Taxpayer Advocate Enhancement Act. Some of these things are, all of these things are components of the Taxpayer Assistance and Service Act that are working their way through Congress right now. One of the things I'm really excited about, Josh, are the provisions of the well, let's just call it the TAS, Taxpayer Assistance and Service Act, that relate to the right to judicial review of IRS decisions. If this thing passes Congress in the way that it's proposed right now, I think it's going to be very helpful to taxpayers' rights when it comes to litigating with the IRS.
So am I to understand that before this bill, and as it is now, you don't have the right to judicial review on a tax case? You don't have the right to have a court look at the case and say, hey, the IRS isn't doing something right here?
Well, yes, you do have the right to judicial review, Josh. There's no question about that. And you have right to judicial review in two courts, either the United States District Court. If you're claiming a refund, you have the responsibility to pay the tax first, and then you can sue for a refund in the United States District Court, which is very cumbersome and often very expensive. And the second option, generally speaking, now there's more options than this, but generally speaking, you've got the right to go to the United States Tax Court, which is a prepayment option. If you're fighting with the IRS over an audit and the IRS says you owe $50,000 and you disagree, you've got two options. Either pay the taxes for a refund, or you go to the United States Tax Court as a prepayment option. You don't have to pay the tax first. So yes, you do have the right to judicial review, but there are some limitations. Taxpayer Assistance and Service Act is going to change and remove some of the barriers that are in place now to get judicial review. And maybe we can talk about some of those things.
You've got a list here of all the different aspects of the judicial review. The first one being the authority to vacate judgments. What does that even mean?
Well, what that means is when you go to the United States Tax Court and you get an order from the tax court and that order is wrong, the tax court has very limited authority to vacate its judgment, to set its judgment aside as though it never existed. Now, in the United States District Court, the courts have far more latitude to vacate judgments that are based on fraud or mistake or newly discovered evidence, but the tax court doesn't have the same right to do that because its rules of procedure are different. Under this act, the rules of the tax court would be expanded to allow us to go back into a case and reopen a case where a mistake was made. I represented a client years and years ago that was represented by another attorney in her tax court case, and that attorney, without her authorization, waived her right to go to trial. I went back and tried to have that decision vacated so she could go to trial on the merits of her case, get the facts and circumstances of the case reviewed by the tax court. And the tax court said to me, we don't have the power to vacate this decision. That lawyer committed malpractice by giving away her rights without her knowledge. And I was not able to undo that decision because of the narrow scope of the tax court's rules. If this passes, those rules are going to be opened up, and I would, under the same circumstances, have the right to, now this happened 25 years ago, so I'm not getting it done now, now. But the point is, if that kind of case came to me again, we would be able to reopen that case and get it resolved through tax court litigation.
It begs the question, how far back would you be able to go in order to reverse a decision?
Well, that depends on how the bill is written. But right now, the way the federal district court rules read is that it has to be done within a reasonable period of time. What's reasonable depends on the facts and circumstances of the case. The farther away you get from the court order you're trying to vacate, the more difficult it is.
So the next thing on this list is the right to review IRS decisions on tax credits. Now, my understanding of tax credits is it's money that you get back from the IRS based on facts and circumstances, but they are just allowed to disallow them at any given point.
Well, yeah, what happens with these tax credits, and this is a bizarre thing because, you know, if you've got the child tax credit, for example, or the earned income tax credit, millions of people claim the earned income tax credit, which is a credit for low income earners, whether you're self-employed or a wage earner. This is a refundable credit. And when it's a refundable credit means that you get money back. It's actually a welfare program, Josh, administered by the Internal Revenue Service. That's what a refundable credit is. They're giving you back from the government that you never paid in the first place. So you get more back from the government than your tax liability actually is. Let's say you got $1,000 tax liability and a $2,000 credit. The $1,000 tax liability goes away and you get another $1,000. The credit is money in your pocket. Well, what happens is if the IRS does an audit of you and they disallow credits because you are not eligible to pay to claim those credits, they can actually put you in tax credit jail. They can say to you, okay, Josh, because you made a mistake on your tax return, you can't claim this credit anymore. It's an arbitrary thing that the IRS does that says you can no longer claim this credit until we feel like giving it to you, even though in subsequent years you might fully qualify for the credit. They're not going to give it to you because you had one disallowed a while ago. Now, under this bill, there will be a very important change to the law. That change would require the IRS to send you a written notice saying they're putting you in tax credit jail. That notice would give you a right to go to the United States Tax Court to challenge it. And that's a very important right. The IRS would not have unilateral authority to deprive people of tax credits. It would give the taxpayer an opportunity to go to tax court. The United States Tax Court is the prepayment option. So you don't have to pay the tax first, or you don't have to jump through any other. When the IRS sends that notice, that's your ticket to court. You file a petition in the court. You get an opportunity to sit down with the appeals office. You get an opportunity to sit down with the IRS attorney assigned to the case. It's called the Office of Chief Counsel, where the attorneys represent the IRS in these cases. And then worst case scenario, you have a right to tell it to a judge. So this would be a very, very important development to be able to challenge those determinations.
At the absolute whim of a bureaucrat when it comes to the fact that these tax credits, this tax system is overly cumbersome and overly complicated. So making a mistake and then being at the mercy of a bureaucrat because of one clerical error is insane. But the fact that you can't even challenge it, that's another level.
It's unconstitutional, Josh, because the Constitution, of course, gives you the right to due process of law, which means a notice of government action and an opportunity to respond, an opportunity to present your case. And that's one of the key elements of the so-called Taxpayer Bill of Rights, which is in the Internal Revenue Code. One of the key elements of the Taxpayer Bill of Rights, Josh, is the right to challenge an IRS decision and be heard. Well, when it comes to the tax credit jail, right now, you don't have a right to be heard. Say again?
I said it's more like a gulag than a jail. At least in jail, you get your phone call.
Well, that's true. That is true. But, you know, the good news is that unlike the gulag, they're not working you to death.
I think the metaphor with the IRS is
when half your income goes to federal, state, and local taxes combined, are they working you to death? Maybe they are.
I think the metaphor is pretty solidly there. I'm going to stick with it. Number 3 on this list here, though, is de novo review of innocent spouse determinations. Being an innocent spouse of a tax situation can be an absolute nightmare, especially if you had no idea what was going on in the first place. But what does the words de novo, D-E-N-O-V-O, what does that mean? That sounds like
it is Latin, and what it means, and let me just, I won't give you the literal definition, but very simply, it means a do-over in court. And this is a very important change to the law. When we're talking about innocent spouses, let's just talk about this very generally. An innocent spouse is married to a person who either earned income, they didn't report on a joint tax return or fabricated deductions on a joint tax return that the innocent spouse did not know or have reason to know about. So the innocent spouse didn't know about the income or the bogus deductions. The innocent spouse, she signs that tax return believing it's accurate. Turns out that it's not accurate. And the additional tax liability, it could be $1,000, it could be $1 million. The additional tax liability becomes assessed against both spouses, Josh, because when you sign a joint tax return, whether one person or know the income or not, both people are jointly and severally liable for the tax in that return. That's why it's a joint return. They both become responsible for the liability. But the innocent spouse procedure allows the unwitting spouse to step forward and say, hey, I didn't know that there was unreported income. I didn't know that there was bogus deductions. I shouldn't be held responsible for the tax liability on that income and those bogus deductions because I had no idea what was going on. So that's the whole concept of the innocent spouse, and it's very effective under the right circumstances. I've prosecuted a number of these innocent spouse claims on behalf of clients over the years. The last one I did, this is no BS, I'm not making this up. I did a innocent spouse presentation on behalf of a client a couple of years ago. This particular case was set for trial in the U.S. Tax Court. And before the case went to trial, we had a conference with the appeals office who had the authority to recommend settlement of the case. And so what I did with that appeals officer is I presented my client and I took my client through her testimony the way it would be given in the court. And then I had a couple of witnesses that we were going to call in court. And I took those witnesses through their testimony the way it would be in court. Instead of doing it to a judge, I did it with an appeals officer, and that served two purposes. Number one, it was to prep my clients for testimony, right? It was to give them some practice so that when they go to court, it wouldn't have been the first time they gave their testimony. That was one thing. But the other thing was the appeals officer had the authority to recommend settlement. And so this was an opportunity to avoid the trial. We did a mock trial with the appeals office where I presented my client's case through that testimony of the woman that representing and a couple of witnesses that we had. Well, when we were all done with this, it took about a half a day. When we were all done with this, the appeals officer completely agreed with my position, completely agreed that my client was in as a spouse. And here's what she said. Now, she said, and this is a quote, she said, Dan, you were spectacular in presenting that case. And so so what happens here is you really need to know how this innocent spouse works to get the case resolved. But what this change will do is it will allow us to present all evidence to the tax court, whether it was presented to the appeals office or not. The word de novo means it's a do-over, to start from scratch, a fresh look at the case by the judge. What happens now in these cases is if you don't present evidence to the appeals office in your appeals conference, the court will not allow you to present that evidence in the tax court trial if you don't win at the appeals level. This is very limiting because you don't always have access to the witnesses and the information as you're going through the appeals process. It's very common for new things to be brought to light, to be newly discovered evidence, to have stuff available now that wasn't available then. So what this change will do is it will rewrite the innocent spouse statute to say that the court can look at any evidence, whether it was presented to the appeals office or not. And this is a vitally important change that's going to help taxpayers tremendously.
Yeah, that seems quite unfair and limiting to have only evidence that you presented not be admissible in court.
That's exactly right. And it's really contradictory to the language of the statute. One provision of the statute says that it is de novo, and then another part says, no, you're limited. The courts enforce the limitation, but not the other, not the other broad portion of the statute. So this is going to end the confusion and make it clear that we can bring any evidence in before the court on this issue.
The next item on our list here is tax court with jurisdiction to apply equitable tolling rules, which just sounds like a bunch of jargon. First of all, what are they tolling? The rules need to be equitable.
If I lived to be 500 years old and was able to be in this business that entire time, I never would have guessed that this would happen. Now, let me tell you what's going on here. When you want to take a case to the United States Tax Court, you got a fixed period of time in which to file your petition with the court. We were just talking about innocent spouse cases. So what happens in an innocent spouse case is if the IRS appeals office if the IRS turns you down, they issue a notice of determination, and that notice of determination gives you 30 days to file a petition with the U.S. Tax Court. That time period is fixed by law. If we're talking about an audit and the IRS comes back from your audit and says, oh, Josh, we're done with your audit, they mail out what's called a notice of deficiency, and that notice of deficiency gives gives you 90 days to file a petition in the tax court. We could go down the list of about 8 or 9 different time periods that are applicable to filing these cases in the tax court. All of these time periods are fixed by statute. I have told my 2,000 times over the year that if you miss that deadline, you lose the case, you lose your right to review in the tax court, and you're simply stuck. So we can't miss the deadline. Along comes the courts starting in 2022, and they said, no, that's not exactly what the law is anymore. There was a Supreme Court decision in 2022 that came out and said, no, that's not exactly what the rule is. If a person misses their deadline and they've got a good reason for missing the deadline, then we can actually extend the deadline. We can stop that clock from running, and we can receive a petition that's late. Maybe it's 10 days late. Maybe it's 10 months late. There's no rule on this anymore now. All right. So what equitable tolling means is that there are facts and circumstances in the case that require the application of a fairness doctrine. That fairness doctrine would say if a person took reasonable steps to do the things they were required to do, and due to circumstances beyond their control that they could not foresee, illness, injury, natural disaster, then the court has the authority to extend the deadline to the point where they will receive their late filed petition. Josh, I fell out of my chair when I read this Supreme Court case. The case is Belcher versus Commissioner. It's a 2022 Supreme Court decision. I talked about this in my newsletter at length. And since that decision came down, the tax court has applied it, and circuit courts of appeals have applied it to different areas. So now we've got this equitable tolling rule that will be adopted as a matter of law by the Taxpayer Assistance and Service Act. This is a miraculous development that, as I said, I never would have predicted in 500 years.
So finally, there's a little bit of leeway because of facts and circumstances. If tax litigation could be summed up in 2 words, it would be facts and circumstances.
And that's a very astute observation, because when we're dealing with tax laws on deductions and so on, these kinds of things, it all turns on what the facts and circumstances are of your case. And I'll just give you a perfect example, a very common example. The deductibility of business miles for a self-employed person. Can you deduct this mile or that mile? Well, the answer is it depends. What are the facts and circumstances of your case? You, Josh, in the business you're in, may be able to deduct mileage for this kind of driving, but me in my business, I would not be able to deduct that same mileage. So everything boils down to a facts and circumstances determination.
The next item on the list is clarification of tax court jurisdiction in CDP, collection due process cases. Tax jurisdiction is important. But what does this mean?
The tax court jurisdiction means authority. When we're expanding the jurisdiction of the court, we're giving them more authority to look at more types of cases. In this situation, the tax court has the jurisdiction to review the underlying tax liability that's in dispute in a case in certain circumstances. All right, but not in every circumstance. So what this situation does, Josh, is it expands the court's ability to look at the underlying tax liability in collection due process cases. Let's talk about collection due process for just a second, because people need to understand what this is. In my opinion, Josh, this is probably the single most important right that taxpayers have when they're dealing with the IRS, is the right to challenge IRS potential proposed collection actions through a collection due process appeal. So what happens is, if you owe the IRS money, they can't seize so much as a postage stamp from you until they send a final notice of intent to levy and notice of your right to a hearing. When you receive that notice, you have 30 days. That is not subject to equitable tolling. You've got 30 days to request a collection due process appeal. That takes the case out of the hands of the collection function, puts it into the hands of the appeals office, where the written job description of the appeals office is to review the propriety of the assessment to make sure it's accurate, and to consider potential collection alternatives raised by the citizen, and to perform a balancing test, which balances the IRS's need to collect the revenue against the citizen's desire that collection be no more intrusive than necessary. So these are important protections that citizens have. But you can only challenge the underlying tax liability in certain circumstances. What this bill will do is expand the circumstances under which you could challenge the underlying tax liability to give you more options if you don't believe you owe the tax. This is a very important development. Again, this is not law. Let's caution the viewers. This is not law yet, but this is an area where you want to get in the face of your senators and U.S. representative to get them behind pushing for the Taxpayer Assistance and Service Act.
If there's one thing on this entire list list for you to take and bring to your local or to your federal Congress people and say, hey, we really need this bill to happen. It's probably that collection due process thing. Because
yeah, no question.
the next on the list is authority to issue refunds in TDP cases.
And this is critical as well, Josh, because we talked about the tax court's jurisdiction to look at the underlying tax line, and the tax court may say, yeah, not only do you not owe that, but the IRS owes you money. But the problem is the tax court has no jurisdiction to order the IRS to issue a refund. So you could win your case in tax court and get an order from the tax court that says, yeah, the IRS owes you $1,000, and the court can't force the order. Now you have to go back through a whole different judicial process to get your money. So what this would do is give the tax court jurisdiction to order a refund or a credit in a collection due process appeal case. Very important development if this passes.
What the heck is the point of the court order if the court order doesn't order anything?
This is the problem we're dealing with. The tax court, all federal courts, not just the tax court, are courts of limited jurisdiction. They're not courts of general jurisdiction. Your state court, state district courts are courts of general jurisdiction. They can hear any kind of a case. Jones versus Smith, state courts have the authority to hear it. Federal courts are courts of limited jurisdiction. They have only the authority that Congress gives them. The United States Tax Court was intended to be a court that would adjudicate disputes between the IRS and taxpayers over audit determinations. Audit determinations. You either owe the money or you don't as a result of an audit. And that's how it started out. And that started out that way in the the early part of the 20th century.
So essentially, more or less, because the IRS keeps getting more and more nonsense under their purview, their power expanded beyond the range of the court to be able to say, no, stop doing that. And so now we have to come up with another law that says, hey, the court can tell you to stop doing that. Is that what's happening here?
That's a succinct layman's way to put it. But yeah, as over the years, courts' authority has expanded by statute to cover issues that didn't exist 100 years ago. That's a reasonable way to say it.
Well, it's an insane way to think about the fact that the IRS, the tax code itself, the income tax in its entirety needs to be ripped out and started over and replaced entirely because it's just too complicated. And the fact that the IRS tax court has to be powered in order to say that the IRS can't do the things that it's doing makes no sense to me. The last item on the list is tax court jurisdiction to hear refund cases. This is another instance of the IRS growing beyond the purview of the tax court and it needing to be reined in.
Well, this is a little bit different. This is the first cousin of the issue we just talked about. We talked about refund jurisdiction in collection due process cases. But let's take collection due process out of it for just a second. Let's say you don't owe the IRS a dime, all right? And you go back and you sit down with your accountant and look at your 2022 or 2023 tax return, and your accountant says, hey, Mr. Smith, Mrs. Jones, you didn't claim all the deductions you're entitled. You should file an amended return and you'll get some money back from the IRS. So you'd say, okay, that's a good idea. If I don't owe the money, I'm going to get it back from the IRS, right? Now, remember, you don't owe them anything, right? You're square, but now it turns out you believe they owe you money because you made a mistake on your return. So you file that amended return, you make your claim for refund, and let's just say it's $10,000. And the IRS says, no, we're not giving you the money back. We don't think you qualify for this reason or this reason. And you disagree. The way it works right now, Josh, is you have to file a lawsuit in the United States District Court in order to get that money back. District court cases are very expensive. They're very complicated. They're difficult to process and prosecute compared to U.S. tax court cases. The United States Tax Court has no refund jurisdiction. What the bill would do is give us an opportunity to file a case in the United States Tax Court to claim that refund, where the procedures are simpler, the case is easier to deal with. The judge in the United States Tax Court only hear tax cases, right? So they are at least theoretically much better equipped and better qualified to evaluate and adjudicate tax issues than judges in the United States District Court. Judges in the District Court might be hearing a federal bribery case one day, a drug trafficking case another day, bank robbery case another day. Those are the kinds of things that federal district judge, here comes a tax case. These federal judges aren't necessarily equipped to answer technical questions with respect to the Internal Revenue Code, but the whole purpose of the tax court is to have judges that do nothing but tax cases. They are better suited to hear these cases in the first place. Under this bill, the tax court would be given that jurisdiction.
It seems just like another instance of why would you have a tax court and then have a whole system that sends you to a different court? It makes no sense. These seem like entirely common sense upgrades, fixes entirely. Are there any other issues, common sense fixes that you think should be added to this bill? You know, sans the whole rip out the income tax by the root idea, which of course is our go-to on this channel.
Well, there's one other element of the bill, Josh, that we haven't even discussed yet. So let me use your question as an opportunity to raise that issue. Right now, under federal law, in order to make a claim for refund, the full tax has to be paid. Tax, penalties, and interest have to be paid in full. If you owe the IRS, let's say $50,000, and you can't write a check, you get yourself on an installment agreement. Okay, fine, you're paying the taxes over time. But now let's say, again, that issue arises where, well, wait a minute, I don't really owe this money. I should be able to get money back from the IRS. There's a 2-year limitation. The 2-year look-back period says you can only recover payments made to the IRS within the most recent 2 years. If you're on an installment agreement and you're paying this tax over time, 3, 4, 5 years, that 2-year look-back period is going to prevent you from getting money back that the IRS really owes you. If under a provision of this bill, that 2-year period is going to be changed when it applies to people under an installment agreement, so you don't lose your right to a refund.
And that seems like common sense, but it really just goes to show the IRS will chase you down. Doesn't matter how many years back you owe them, they'll chase you down, but God forbid they owe you any money. You got 2 years to collect.
Let's be careful about the first part of your statement, though, Josh. There is a collection statute of limitations. So people think the IRS can chase you forever, but they can't. The collection statute of limitations is talked about in chapter 10 of my book, How to Get Tax Amnesty, and I lay that out for you. The basic rule is they only have 10 years from the date the tax is assessed in which to collect it. And if they can't collect in 10 years, they can't collect.
10 versus 2 is still a pretty silly proportion, if you ask me.
There is a big difference.
All right, so they got some expanded refund authority. That was what you were just talking about. Is there any other common sense things that needed to be added into this bill that they've just missed so far?
One thing that we haven't talked about is the aspects of the bill that deal with the taxpayer advocate. And the taxpayer advocate under this bill is going to be given more power as well.
That should be all for this time. Thank you for watching, taxpayers. Remember, there's no such thing as a hopeless tax case. And if you think yours is the exception, get a hold of Dan here. He will help you see the daylight. Dan, tell them where else they can follow along with your taxpayers' rights crusade.
Follow me. I'm at Pillow Talks Taxes, Pillow Talks Taxes. I'm primarily on TikTok, Facebook, Truth Social, and right here on YouTube. Make sure you subscribe, like, and share these videos, especially share these videos with your federal representatives, your United States representatives and your United States senators, particularly when we're talking about this Taxpayer Assistance and Service Act. Get in their face and make sure you let them know that you're in favor of this bill being passed. And if you have a tax problem, go to my website, TaxHelpOnline.com. That's TaxHelpOnline.com, and you will get the help you need. Buy any book at any price point. You get a free 15-minute consultation directly and personally with me.